please the court, my name is Robert Beckham. I'm the counsel for the petitioner Christopher Sanchez, along with Stephanie Vega Graves. This is a case where the county's negligent failure to manage its property for a special event resulted in a large teenage party at night after hours with loud DJ music in a high crime area.
I want to get some clarity here and make sure I understand what you're arguing that the county failed to do that it had a duty to do. And I understand, it's about security. If I understand what you're saying, you're not arguing that the county failed to allocate police resources to providing security at the park. Is that correct?
That is absolutely correct. We are not saying they should have brought police.
Okay. So am I correct in then understanding that you are arguing that the county failed to ensure that the person who rented the pavilion at the park fulfilled the agreement by providing security for the event as required by the agreement? Is that's the failure of the county here?
Well, that's one of the failures of the county, Your Honor. There were
What's the other failure?
Well, there were several others. The record shows, and there's a sworn statement from the teenager who rented the pavilion saying, nobody ever told me I needed to get off-duty policemen. Okay? So the failure to inform him that it was required is negligence. The failure to verify that he had complied.
But it's all about their failures to take action that ensured that he would obtain the required security. I mean, I think all those things you described fall into that category.
Well, Your Honor, they certainly are tied together. Right. There's no doubt about it. And but what we're saying is that the negligent failure to manage this event caused the fact that there were no off-duty police.
Well, but let me ask you this. Let me just conclude with this. Of those things that you've talked about here, did you argue those in the district court?
Yes, Your Honor.
Was that your argument there?
Yes, Your Honor.
The district court says it wasn't, if I understand the district court correctly.
Your Honor, that's what the majority opinion talks about that. But I think it's clear that we argued it. Look at the dissent from Judge Salter. He understood what we were arguing.
I would rather look at your initial brief in the district court.
Yes, Your Honor.
Tell me where that is in your initial brief in the district court. It's in an appendix that was filed with us.
Yes, Your Honor. Let me.
Because candidly, I looked through there and I could not find that argument. I find lots of general talk about the law, but I cannot find this argument, and perhaps I overlooked it, and that's why I want you to help me find it. I can't find this argument that is focused on the county's failure to manage the performance of the person who rented the facility. And I think I'm just not seeing that in your initial brief.
Well, Your Honor.
And a dissent does not an initial brief make, okay? I mean, it's got to be your argument.
Yes, Your Honor, I understand. Let's go to the summary of the argument. We talk about when the government undertakes to operate a park, it must do so in a reasonably prudent manner, just as a private individual under like circumstances. Once a governmental entity builds or takes control of property or an improvement, it has the same common law duty as a private person to maintain and operate the property. So But
I see nothing in here. You talk about whether they negligently failed to provide adequate security, but that's suggesting that the county had a direct obligation to provide the security, not that they had an obligation to manage this contractual relationship to require that the person who rented the facility provide the security. I just don't, again, is that the best you can come up with?
No, Your Honor. On page 16 of the brief, I believe it's page 28 of the record, it talks about how the county had ordinary premises liability duties. And
I'm asking specifically about what you are specifically arguing here, which is that the county had this obligation to manage the performance of the person who rented the facility.
Your Honor, this has been our position at every level. It was our position in the trial.
But I understand you're saying that, and that's your position that you're taking. I'm asking, where is it in the initial brief in the district court? And if, I'm not going to keep at this. I mean, but that's my question.
All right, Your Honor. The thrust of the initial brief, and especially if you look at the facts that are developed in there, it's all about how the county did not ensure and verify that the teenager brought the required security. It's the focus of all of the facts, Your Honor. And the argument we made in the brief and in the oral argument have been the same. In the trial court, the county understood what our argument was. If you look at their jury instructions on page of the record 287 and 291, Florida Standard in Jury Instructions 401-2 and 401-18, it talks about the issue is whether the county was negligent in the operation of the park.
So, counsel, but if you're not talking about the security, then doesn't that take away the conflict with the Woodson case?
No, Your Honor. I think there's still a conflict with the Woodson case because in the Woodson case, there was an unauthorized gathering of teenagers where there was liability. And here, and it was authorized even. The county can't even claim, oh, we didn't know these people were going to show up.
But I'm reading, if I read the Woodson case, which is very brief, it says that the city breached its duty by failing to provide adequate security for the teen dance when the city knew from past experience that such dances were dangerous events. So you're saying your case isn't, notwithstanding what the Third DCA said, you're saying it's not about negligent security. So I mean, there's no way that we would know from the Woodson case that had anything to do with the kinds of things that you're saying now are the negligence.
Well, I think you're right. The Woodson case is relatively brief, but what the Woodson case does say is that it was a negligent failure to operate the premises, and that's what I was trying to point out earlier. What our initial brief in the district court also talks about is the failure to operate the premises correctly, and that's what we have here. If the premises had been operated correctly, there would have been the off-duty officers there, and all the evidence, although it was stricken, but it shouldn't have been stricken, we don't believe, was that this situation made this kind of event, or I should say, this kind of shooting foreseeable and preventable. And this is a summary judgment. The plaintiff or the non-moving party is entitled to all the inferences, and we think we didn't receive them in this case. What I would like to point out is that it's critically important that the teenager who rented the pavilion said, nobody told me about this. And if you're not told about the requirement to get the off-duty policemen there, how are they going to know? I mean, we're not questioning the fundamental decision to provide security or not provide security. We're not questioning the fundamental decision to rent the pavilion or not rent the pavilion. We're just talking about how the rental was managed, and it was managed negligently.
So it's your position, if absent this contract, a contractual relationship, say there'd just been a practice here of having people to come in and sign up to get access to the pavilion. You just came in and signed up, nothing more than that, and then things happen just like they did subsequently, then obviously, it'd be your position there's no case.
Well, Your Honor, I don't know about that, but those aren't the facts we have here. What we do have here is the county knew that we know that the county knew this sort of thing was foreseeable, and that's why they had the requirement for off-duty police officers to be at an event like this. And where there's a foreseeable zone of risk, there's a duty. And this duty deals squarely with...
Well, but we know that that's not always true with respect, that's certainly not true with respect to enforcement of the laws. And, you know, the police can know that there's a problem in a particular neighborhood, and they are not going to be held liable for failing to go there ordinarily. Isn't that correct?
Yes, Your Honor, and that's, of course, where the Trianon case instructs us. But we go here, this is clearly a Category 3 function dealing with the maintenance and control over property.
But you're making, I mean, by this argument about not enforcing the rules and regulations, it's almost like you're making it a Category 1 or 2 case.
No, Your Honor. Again, we're not questioning the fundamental idea of renting the pavilion, or holding the event, or even allocating police officers. They've decided to operate the pavilion this way, and they have the same duty as an ordinary private person would under the same circumstances.
Why wouldn't it be reasonable to look at this as a permitting decision? There's some, permits frequently involve some compensation for the permit, and a permit condition. And the issue being here is whether the city policed the permit conditions that were provided for the permit to have access to this property. Why wouldn't that be a sensible way, and maybe the most realistic way of looking at what was going on here?
Well, Your Honor, because what we're dealing with here are the secondary decisions that the county made implementing a policy. We're not talking about permitting. We're talking about how they didn't do these things, that the zone manager of the park says everyone knew this, okay? But apparently they didn't. They had a new park manager. She apparently did not know all the rules. The zone manager said the park employee in attendance should have known the rule, but apparently he didn't know the rule. These are...
Well, he was the guy who policed the trash cans in the bathroom.
That's right, Your Honor. He was...
How could you hold him to that responsibility?
Okay, but the point is, the zone manager said everyone should have known this needed to be done. Everyone should have known that this was required, and yet it wasn't. And there's evidence of negligence here. And on a summary judgment, we're entitled to let the jury decide that issue of negligence. If there are no questions, I'll save the rest for rebuttal.
Good morning, and may it please the court. My name is Joni Mosley, and I represent the respondent, Miami-Dade County. I'm here to ask the court to affirm the decision of the Third District Court of Appeals on the basis that the county is sovereignly immune from liability in this case, but also for the additional reason that the county did not owe Sanchez a duty of care. This court accepted jurisdiction over this matter based on a conflict between the decision below and the Woodson decision in the Fourth District Court of Appeals. Woodson, however, is no longer good law, as the opinion conflates duty and sovereign immunity, and that's a practice that this court condemned in Wallace versus Dean. For a very long time, as early as 1989, this court has been very clear that...
So basically, your position on that is that there may be a technical conflict, but there's not a live conflict.
Exactly, Your Honor. Exactly. As early as 1989 in Keisner versus Cope, this court has instructed that the question of duty and sovereign immunity are two different things. Actually, the issue of sovereign immunity doesn't even arise until there is a common law duty found. The court found the same thing in Pollock versus Florida Highway Patrol. The Woodson decision makes a determination about duty, and then in the very next sentence or the very next word concludes that the city did not have sovereign immunity. It does not do an analysis of both. In addition to that issue, the Woodson opinion does not analyze what the actual allegation of negligence is. It focuses instead on where the negligence took place, which is on government property. Based on that, it concludes that this is a Category 3 Trianon analysis. But in reality, in the Woodson decision, like here, the allegation of negligence is failure to provide security, protection of the public. And if we look at the Mills decision of this court warned not to tie the allegation of negligence to where it happened. In the Woods decision, it came to this court based on a conflict between the First District and the Third District. And the First District cases involved slip and falls at a courthouse. The Third DCA case involved an allegation of negligent security at a courthouse. This court found that the Third District case, which concluded that there was no duty because the allegation stemmed from the operation of the courthouse. So this court concluded that while the result was correct in that there was no duty of care, the way that the court got there was incorrect, because the court, like the court did in Woodson, tied the allegation of negligence to where it occurred. In reality, what should have happened in the Zeha case, that was the Third DCA case that the Mills decision looked at, what should have happened in the Zeha case is that the court should have found that there was no duty of care because the allegation was negligent security, because it was a protection of the public issue, which is a Trianon Category 2 issue, which the government would have no duty for.
Well, in Mills, doesn't it seem to suggest that Judge Schwartz and his concurrence in the Third District opinion, in bank opinion, got it right?
It does, Your Honor, it does. So based on that, the county argues that this is really a Category 2 case. And the reason that we argue that is based on the arguments that have been made by petitioner throughout the course of this litigation. From the trial level to the Third District, this has been a case about negligent security. This has been a case about the county's supposed duty to have off-duty police officers at the location for this private party. And because that's been the allegation throughout the course of this litigation, this is a category.
This is kind of a strange concept of the county having off-duty officers there, because in a way, if the county has them there, they're on duty.
Right. Well, Your Honor, exactly. That's a distinction without difference. And if we look actually at what plaintiff's expert had to say about the police force and why that was necessary, let me go back for a minute. First of all, there was security at this party. Mr. Salgado, the person who rented the pavilion, had 2 security officers there. Plaintiff's expert, Lieutenant Howard, testified that those security officers would not have been enough. And the only appropriate measure of security that there could have been at this party were 2 police officers. And the reason for that, he testified, is because of their ability to make arrests, their ability to summon other law enforcement as backup, the things that only police officers can do. And so what petitioner is attempting to do, he's couching this in a premises liability context. But what this is a failure to have police officers at a location, a failure to enforce the law, and a failure to protect the public. That's what the allegation really is. You know, tying it to the property creates a lot of issues, because what you're going to have is an erosion of protections for Category 2 functions of government and Category 1 functions of government, depending on where it is. Quite often, police officers go to public spaces. And so the argument will then become, well, because the county didn't have enough police officers in this public square, the county is now negligent, because this occurred on the county's property. And
I'm sorry to interrupt you, but you're kind of bouncing around a little bit from all the different issues involved. So do you have a problem with the way the Third DCA looked at this case? I mean, they punted on / assumed duty, they went straight to sovereign immunity, and they did the Category 3 analysis, and they put it in the discretionary category and said, therefore you win. Is there any problem with that?
Well, Your Honor, I believe that the district court was absolutely positively correct with its sovereign immunity analysis. But I do argue that the district court probably passed the issue of duty too quickly, because this really is either a Category 2 under Trianon, or if we look at petitioner's argument today, it would be Category 1 under Trianon. But I don't quibble with the Third District's decision, because ultimately the county prevailed there, and the county is sovereignly immune. But in this instance, the county, first of all, does not have a duty of care.
Okay, but hold on. So you're okay then, you don't have a problem, I'm not surprised with the sovereign immunity analysis. Now, if we go to the duty issue, how do we deal with, if we want to look at it your way, how do we deal with the fact that this is a park that the county is operating? And it sounds like some of the arguments you're making clearly would be applicable if you're just talking about a duty to the public at large, but when you're talking about in the specific context of a facility that the county is responsible for and that's operating, I mean, what's your argument for why we should sort of use this case as an opportunity to get into that issue?
Well, if we look at the Mills case, in Mills, all of the allegations of negligence happened on county property at the county courthouse, right? But the court instructed that we have to look at what the actual allegation is. What was the failure? And because here the failure, as it was in Mills, the failure was the protection of the public. So that's why it's a Category 2 analysis as opposed to a Category 3, despite the fact that it happened on county property. Petitioner cites the Abalone case, and it cites a lot of cases that cite to the Abalone case. And I want to talk about an important distinction between the Abalone case and negligent security cases. The Abalone case deals with government's duty concerning public swimming areas. And it's important when we look at that case, this court talked about common law duties of care that existed prior to the waiver of sovereign immunity. So even prior to the enactment of 768-28, government had a specific duty of care as it related to swimming facilities and as it related to having lifeguards at swimming facilities. That analysis does not apply to negligent security cases, because that is a very specific common law duty. If you look at Trianon talks about duties of care, common law duties of care that existed prior to the waiver of sovereign immunity. The duty of care for a swimming facility is one of them, but the duty to protect the public there's never been a common law duty of care. And Trianon cites to Wong and other decisions that predate the waiver of sovereign immunity. And so what seems to be happening in terms of petitioner's argument, and also in terms of some of the other district court decisions that we have, is they're taking the language of Abalone and forgetting that opinion is very specific to the duty of care as it relates to pools. And if you look at some of the cases, when you look at how this court actually interpreted the duty of care as it relates to pools, and I'm looking at pools and swimming facilities and beaches and the like.
I'm sorry to interrupt you, though, but can we just back up a second?
Yes.
Is there any reason why, the Third DCA decided the case on sovereign immunity grounds? The Rothenberg opinion that they kind of incorporated completely punted on duty. This Third DCA opinion now that's under review doesn't really analyze duty. They say it's not a duty case, and it's not clear whether they just assume that there is a duty or they just sort of bypass the issue. Why, if we're kind of writing for the future, what is the problem with the sovereign immunity analysis, if any, that the Third DCA adopted here? I don't understand why you're we're getting into swimming pools and all that stuff. I don't understand why you would want to encourage us to go down that path, unless there's some problem from your perspective with the sovereign immunity analysis that's there. And so I want to make sure that if you do think that there's a problem, that we understand what that is.
Okay. No, Your Honor. There is no problem with the sovereign immunity analysis.
Are you just providing us a tipsy coachman kind of argument to an alternative reason to rule for you on the issue of duty if we were not to find for you in sovereign immunity?
That's precisely right. I'm responding to petitioner's arguments here, and petitioner is essentially arguing duty and sort of based on the existence of duty, saying that there's no sovereign immunity. But yes, Your Honor, I think that the Third DCA absolutely got the case right on the issue of sovereign immunity. But in the alternative, based on the factual scenario, and based on the allegations here, the county takes a position that there was no duty of care either. But yes, exactly. This is a tipsy coachman argument. And because the duty analysis comes first, when we look at these things, I'm arguing duty first. But turning to, well, actually, getting back to why those cases don't apply, those cases that are interpreting abalone, because those are specific to swimming pools. I think the court in abalone said because government undertook to operate a swimming pool or a swimming area, then it had a duty of care. But because the abalone case and all the cases that descend from abalone are very specific to swimming areas, you can't apply that analysis here. The analysis that needs to be applied here is looking at Trianon and determining whether this is a Category 2, which it is, because we're talking about law enforcement and protection of the public. And if you look at it that way, and then you go on and do a sovereign immunity analysis, there is no duty, and we're also protected by sovereign immunity. The decision to place law enforcement at any particular location is a government planning level decision. It's something that involves the county's determination about the use of its resources and its determination about where its law enforcement forces are most needed. And that's true when it comes to police forces, and that's true also when it comes to park rangers. This particular park was essentially an unmanned park, and the county made the decision not to have security officers there and did not undertake to protect the public at that particular location. The county actually was very explicit about not undertaking that duty.
Let me just ask you a tangential question. Are you aware of any cases, just looking back at the duty, where a private landowner, like a nightclub or something like that, is found to have breached a duty by specifically this theory, not having off-duty police officers, having some other type of security?
I'm sorry, Your Honor. Am I aware of any?
The theory was that just as a landowner, forget that this was a
Right.
governmental entity, that the landowner should have had off-duty police officers, that was the only type of security that was sufficient. Are there any cases anywhere in the country that follow that theory and find that you're aware of that like a nightclub or any place, private landowner that has a lot of people there for a festive event, has to have private off-duty police officers?
No, Your Honor. I am not aware of any such case. I have not seen any in my research, and petitioner certainly hasn't cited any case where it was held that the only appropriate measure of security would have been off-duty police officers as opposed to security guards.
So, but that was the opinion, as I understand it, that was not allowed pursuant to the application of the Daubert standard. Is that right, or am I missing that?
That's right.
Yeah.
Below the opinion of, I think, Lieutenant Howard, there was a conflict seemingly between the oral pronouncement and the order about whether Lieutenant Howard's testimony was ultimately stricken. And that's not something that I've addressed in my brief. And actually, even if we consider the testimony of Lieutenant Howard, because I do actually consider the testimony of Lieutenant Howard in my answer brief, Lieutenant Howard's testimony is essentially that the only appropriate measure of security would have been off-duty police officers. And that brings us even further into this being a Category 2 under Trianon, and also...
You don't now mind that testimony coming in?
Well...
It helps you, right?
At this moment, that piece of the testimony, I suppose, does help, right? So it also goes to show that obviously pursuant to the Wong case and other cases, that deployment of police forces, assignment of police forces has always been a government planning level decision. So based on,
So I'm sorry to interrupt you.
Yes.
So if the statute, though, says that government entities are going to be liable to the same extent as private individuals in like circumstances, I understand the arguments about the police deployment, but I mean, what are the duties then in the context of running a park and in the specific context of allowing events like this at a park that you think a county would have?
well, certainly, you know, the county has duties that are tied to the land itself. And so, for example, you know, let's say that there was a sidewalk inside the park that was in a state of disrepair and somebody tripped and fell on that sidewalk, the county would certainly have a non-delegable duty as it relates to that sidewalk. And if that were the case, we wouldn't be here. But those are the types of duties that we have, the types of duties that sort of run with the land.
But a private entity would have more duties than that, right?
A private entity?
I mean, a private entity, I mean, do private entities have any, a private entity offering a similar type of facility, would they have any security-related obligations?
They may have security-related obligations.
And so doesn't the statute ask us to basically compare those obligations and apply similar things to the county?
Well, no, Your Honor. I think that when we're looking at the sovereign immunity waiver that talks about the county being liable to the extent of a private individual under like circumstances, we have to also look at the statute in conjunction with the cases that are interpreting it with Trianon and with commercial carrier. And, you know, there are certain things that only government can do. And only government assigns or deploys police officers to a location. And so, you know, no private property owner that I'm aware of would have any obligation to have police officers as a security force on their property. They
Right,
wouldn't
and
be
that's why I'm
obligated.
asking, what are the things that you think would be comparable to what a private entity would have to do that aren't taken off the table by the discretionary function sovereign immunity analysis?
Right. You know, as I said, the type of things that I suppose would run with the land. Would a private individual have an obligation to provide security? Maybe under certain circumstances, yes. But government doesn't have that obligation because we're talking about a Category 2 function. Do the justices have any other questions for me? No? All right. Well, on the basis of, I'm asking the court to affirm the decision of the Third District Court of Appeals. The Third District absolutely got the issue of sovereign immunity right, but I'm also asking you to affirm on the additional basis that the county did not have a duty of care. Thank you.
Your Honors, to go back to there were supposedly some private individuals that may have been security at this event, but the county's employee who was there at the time said he didn't know if they were legit securities, to use his 2 words. So I think there's a question of fact there on summary judgment. And there's no erosion of any rights or anything. We're simply asking that the county be held to the same standard as a private person would under the same.
I mean, was that ever your theory that I don't recall that being ever argued, that the security was inadequate in and of itself, that these people just weren't trained enough? I mean, the theory was very specifically that they had to be off-duty police officers, correct?
Well, yes, Your Honor,
Okay.
and we brought up what I just said. I believe it's in the facts, just because they made this argument below,
Okay.
and we wanted to anticipate it here. I want to touch, I guess, briefly on the City of Jacksonville versus Mills and Ciega case. This case is like Mills, where it says a premises liability.
Well, let me just back. So you followed up by saying that you're just asking that the county be treated like any other private landowner. Are you aware of any duty to have off-duty police officers that applies to private landowners and recognized in any jurisdiction?
Well, Your Honor, I think the rule is that a private landowner, or any landowner or occupier of land, has a duty to provide adequate security. And that may change depending upon the circumstances. The evidence in this particular case is that under the circumstances, 1 or 2 off-duty police officers was required. And the park zone manager said, why do you want off-duty police officers? Because off-duty police officers is what the county wants. It's not what the plaintiff wants. That's what the county requires. And he was asked, why do you want off-duty police officers? And he said, because folks don't do the normal stuff when off-duty police officers are there. So this was clearly foreseeable to the county, because they're the ones who required the off-duty police officers. But they didn't follow through in administering the park, and we say that's negligence. Back to Mills, if I may. It says that premises liability is a Category 3, and it admonishes us.
Well, but it clearly suggests that this security claim that had been made in the case from the 3rd District was different and would not lead to a finding of liability. Isn't that correct?
Under those circumstances, yes, it's.
Well, then doesn't it seem to doesn't it seem to be about the only way you can read what the majority is saying in Mills is that they're agreeing with Judge Schwartz?
Yeah, I agree. It does not expressly say we adopt Judge Schwartz, but they cited the whole opinion, and I think it's implicit that the court agreed with Judge Schwartz.
They're saying the security in a courthouse is different than a slip and fall on a courthouse.
I don't think so, Your Honor. I think what the court was saying is we agree with the latter analysis. While the case was properly decided, the majority opinion in Zieha placed too much emphasis on the location where the injury occurred rather than the nature of the act which brought about the injury. Okay. The nature of the act that brought about the injury in Zieha was an escaped prisoner. Okay. The prisoner got free, apparently became armed, and took a hostage, and the plaintiff was injured. Okay. There are plenty of cases that saying that the county or the state is not liable for what an escaped prisoner does. Okay, that's what happened in Zieha. An ordinary person doesn't have a duty to protect against an escaped prisoner. A private person doesn't have that duty. Okay, that's why the Zieha case was decided the way it was. In this case, a private person under the same circumstances would have the duty to provide 2 off-duty police officers. That's what the evidence in this case shows. It was a summary judgment. We're entitled to present the evidence to a jury. If there are no further questions, we'd ask the court to reverse the summary judgment and reverse the 3rd District opinion affirming. Thank you.
All right, we thank you both for your arguments. The court will now stand in recess for about 10 minutes.
All right.